Hello and welcome to the Rogers Brief for November 27th, 2022. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to talk about a few things today. As you know, in these videos, I like to cover issues that are in the news in Canada, across the country, that have legal issues at their forefront, or else legal angles that might be underappreciated. This week, I'm going to talk about four things. I'm going to talk at the end about the Emergencies Act Inquiry, which had a big week this week. It wrapped up its proceedings and completed the week of testimony, which was, one cabinet minister after another, some senior government staffers from the federal government, and then finally the Prime Minister on Friday was on the stand for about 5.5 hours, so a long time. Lots of testimony and cross-examination, so that's certainly a unique situation. So I'm going to come to that and give my interpretation of that. I talked about this some last week, and so some of the analysis that I gave last week, for those that watched that video or listened in, certainly came to pass this week. So that was something of interest, but I'll get to that. I'm going to start off with the Mass Casualty Commission out of Nova Scotia. We've had the final submissions from all the parties, the written submissions posted to the Mass Casualty Commission website. So I'm going to go through some of those, not all of them. There's quite a few from the participants. And then a couple of other stories that were in the news this week. One from Nova Scotia, a child protection matter, which I think people might find interesting. And then get some international news as well. There was a case out of the UK, which I think would... people that are interested in international law might have some interest. So I'm going to spend most of the time, though, talking about the Mass Casualty Commission and the Emergencies Act inquiries. Okay, so first is the Mass Casualty Commission out of Nova Scotia, and the closing submissions from all of the participants have now been posted to the Commission website. It looked like, and this was done in the Desmond inquiry as well, that each of the parties were given a limit as to the length of their submissions. It looked like that was about 40 pages. That was the maximum. That's not unusual. That's the way an appeal court brief factum would be, have some limitations on its length as well. So that's fine. You have to get across your point in a limited amount of space. That takes more skill than going on at length for hundreds of pages of material. So I read through. Okay, so the participants, the family participants, or the participants on behalf of the victims' families, were represented by Chester Law, MDW, Bertram McDougall, Lenehan Musgrave, and Patterson Law. I read through those briefs. Those were all really well done. Anybody that's been following the Mass Casualty Commission throughout will be familiar with many of the points raised there, and many of the points that I've also been raising over time in my submissions and in my report, the Deficits of Trust report, which, plug again, I guess that's still available for as an ebook on Smashwords, Apple Books, or anywhere you get ebooks. And hoping to get some hard copies as well at some point of that. So hopefully have an announcement on that in the weeks to come. So those were all the firms that I just mentioned. They all had nice submissions, close to 40 pages. There's a couple of them that were quite short. The Blois, Nickerson, Bryson submission from my friend Tom McDonald, that was only 5 pages long. Lisa Banfield's lawyer, Jim Lockyer, actually it was an associate of James Lockyer, that did their submission. That was only 8 pages long, so that was notable, I guess, for its brevity. But some of the other ones that I thought I wanted to spend a little more time today discussing were the governments and the police association reports, and then some of the other organizations that were involved. So the federal government's submission was really interesting. This made the news as well a little bit. They've admitted some fault throughout their submission. They don't quite say that they admit fault. They frame it in the same way that the Commission is framing its work in terms of recommendations for the future. It's not finding of liability or fault on anyone's part, but rather, all right, here's how we're going to do things differently, which is sort of the flip side of the same coin. Because certainly if you have a recommendation for the future, it would typically mean that something wasn't done right or could have been done better. So they talk about communications lessons, and there's lots of those. Training on usage of the radio system, training on pictometry, which was the mapping system, which some of the senior officers didn't know how to use, night vision goggles, and so better equipment for going out into rural areas and the wooded areas at night. Family liaison training. This came under fire with the RCMP having 2 family liaison officers for Heidi Stevenson, Constable Heidi Stevenson's family, 1 family liaison officer for everybody else. So, like I say, these are all roundabout admissions that I suspect, well, I'm sure, will be used in the civil suit that the victims' families have going on against the RCMP. That the RCMP, through the Federal Department of Justice, has said, well, these are lessons to be learned. Well, I'm sure that in the civil suit, that'll be taken as a civil admission. So we'll see how that unfolds. A couple of others, the Atlantic Police Association, and then also the Nova Scotia Chiefs of Police Association, both advocated for a new model of policing in Nova Scotia, but not a Nova Scotia police force, as the Police Act of Nova Scotia contemplates, but rather a regional model of policing. So, there might be 5, 6, 7, 8 regions in Nova Scotia, each with a police force, each of which would have similar standards, would have interoperability capabilities, so they'd be on the same radio system, using a lot of the same technology, so that if there was something near a border, or whether, they had to bring in, reinforcements from another district, that everybody would be on the same systems. Well, it's not quite clear to me, and there was no compelling argument or no real attempt at an argument made in any of these submissions as to why a regional model with complete interoperability rather than a provincial model, which would have one system. Why is this regional model preferred over a provincial model? Curious to me as to why that distinction really wasn't flushed out a little more and argued in a compelling way. If they're looking for regional models, based on some of the existing police forces, the municipal forces in Sydney and in Halifax and some of the other jurisdictions, why a regional model would make sense, but that was their submission. The provincial government, the Attorney General of Nova Scotia, made submissions, and they really didn't have much to say at all in their submissions, although they used up their space. Basically, the province of Nova Scotia, again, more or less reiterating that they don't want to be the entity that creates or runs a police force, even though it seems natural that they would be. All they said through their submissions is that police funding was in place, proper funding, that victim services, the services offered to families, family members, and community members was adequate in their view, that as when it came to alert ready, that their portion of it, or their perceived portion of it, that the emergency management office was ready and capable of using alert ready. And they talked about domestic violence resources throughout the province, suggesting that there's lots of resources for victims of domestic violence. So that wasn't, they were just sort of saying, here's what we have. Here are the services offered by the province. We think they're okay. We look forward to the recommendations. So not much from the province, as has been the case throughout the Mass Casualty Commission. Next was the National Police Federation, who've really, this is a new organization. This is the union that represents police officers below the rank of sergeant. And not much, anyway, they've really had a hard time establishing or reestablishing their credibility throughout the Mass Casualty Commission. In their final submission, basically what they look for throughout is more money for policing. They don't make any admissions, no admissions that any of their officers made any mistakes or could have done anything better. They simply say there should be more money for policing, there should be more and higher standards for policing, and that what they really mean there is that there should be equipment standards, so night vision goggles, the GPS capabilities for individual officers on their phones to be used during operations. There should be a helicopter strategy plan. Of course, that's true. Another interesting, so mostly they were just looking for more money. Wasn't really a lot of analysis behind that. The one thing they did say, which I thought was kind of interesting, was that there should be, during a critical incident, sort of reminder broadcasts on the radio throughout, just to ensure that everybody has situational awareness, maybe every half hour or however long, maybe every hour, whatever makes sense during the incident, that somebody should come on and say, all right, folks, just to remind us of all where we are, here's what we know, here's what we're looking for, and, rather than hoping that everybody just remembers or has been paying attention to the radio throughout and is situationally aware. So that might not be a bad idea. But again, no real analysis of the situation itself, just sort of, hey, we think police should have more resources. Probably the best written and most compelling brief from what I read was the one from the BC Civil Liberties Association. They say the problems that unfolded over the course of the events of the mass casualty were not resource related, but rather just poor decision making throughout. And that those decisions, not checking in on, not listening to the people in Portapic that told them about these other roads, not listening to, anyway, just not doing proper analysis during the course of the unfolding of events, and that these were made worse by the bloated and hierarchical structure of the RCMP. Now, the BC Civil Liberties Association, who combined with East Coast Prison Justice Society in their submission, recommended what they called transforming the police governance framework in Nova Scotia, and in so doing, have the full participation of marginalized communities. I mean, that echoes what I was saying in my analysis as well, and hopefully the Mass Casualty Commission picks up on that. So those were really interesting. Some interesting in what people didn't say in many cases, but those were the perspectives. The last one I'd mention is there were two from Avalon Sexual Assault Center, lawyer Aaron Breen, and the Nova Scotia Legal Aid submission. Now, Nova Scotia Legal Aid, they weren't questioning witnesses. They weren't really active during the Mass Casualty Commission, but they made a really good submission, I thought. And there's an Avalon Sexual Assault Center. They were focused on the issue of domestic violence and how the treatment of domestic violence issues can be improved in Nova Scotia. And in both cases, they advocated for something of a decriminalization model. And so confronting the issue is most people don't want to report somebody for a domestic violence incident because they're worried that if they get into the justice system, their husband, their partner is, going to lose their job. They're going to have all kinds of financial consequences, all of these things, when really many people want to maintain the relationship. They just need a break for a few days. They need something, to take place, some counseling to be offered to the perpetrator of abuse. So in all those cases, the things that people want and the sort of restorative justice thinking that would, improve a relationship, improve a marriage, and improve a family, home situation, those can't happen with the criminalization and the pro-prosecution thinking that goes behind many of these, policies that the Public Prosecution Service has, and that the criminal justice system and the police involvement requires or usually entails. So basically what they are advocating for is a new model of using domestic violence court, having some sort of carrot and stick model of, all right, well, if you admit what you've done, admit your own fault, take some counseling, get some treatment, improve your relationship, then the criminal consequences of your actions can be set aside. You can go through a restorative justice type process. Well, right now, restorative justice, which is where you do something outside of court and then your charges are withdrawn if you show that you can take responsibility in another way, that restorative justice is not available for domestic violence cases in Nova Scotia. That's a policy decision that the Crown Prosecutors, the Public Prosecution Service has made. And so Avalon and the Nova Scotia Legal Aid Office, who are on the ground, see these situations every day, all the time. This is what they advocate. Hopefully the Mass Casualty Commission picks up on that and makes some changes to the way those situations are treated in Nova Scotia. So those are what I took to be the interesting parts of the Mass Casualty Commission written submissions. So those are all on the Mass Casualty Commission website. They're under the decisions tab of the documents. So you can look there if you want to read through those. If you're looking to read through just a few of them, I would say the Federal Department of Justice one, just to see a little bit of their admissions. The BC Civil Liberties Association submission I thought was really well done. And the Nova Scotia Legal Aid submission I think would be an eye-opener for many people. So go to those ones if you're looking to just read a few. All right, so that's it for that story. One other story from Nova Scotia that just came out this week. This is a Nova Scotia child protection matter, and there was a case with Justice Elizabeth Jollymore. And the issue is, in those cases where there's a permanent care order made. So children are taken away from their parents, put in the permanent care of either a foster home or put up for adoption, often with a relative but could be anybody. Well, there's legislation was brought in 2007 that says where those permanent placements are made by a judge, the judge is not permitted to allow the biological parents any access rights to their children. Now, in many cases, especially where this child's been placed with a relative, they're still in the area of where their biological parents live, or they'll find them online if they're old enough. They'll figure out who they are and try to seek them out. But a judge is not allowed to order that. Now, there's lots of parents. Well, it's not lots, but I think there's 500 and some children in care. It was higher. It was up to 800, but it's gone down in some recent years. But in some cases, the biological parents, even though they may not be capable of looking after the kids full time, there's still a relationship there, and some access can be beneficial. But there would be discretion on the part of the judge to either order that or allow it. Now, since 2007, it was a Liberal government that put this in. 2017. Sorry, not 2007. 2017. That now, when children are adopted or placed in foster care, they're not allowed to order any access to the biological parent. Now, Rolly Thompson, who was my family law professor at Dalhousie, disagrees with this, says it's a power struggle between the Department of Community Services and the courts, a little tug of war, and DCS, Department of Community Services, has the discretion. Their workers can allow these kind of visits to take place, but a judge who is a neutral arbiter of these things is not allowed to. So it seems very strange to me that would be the case. Some children do better when they still have parental contact, and it would makes sense. The Department of Community Services is a they're a party. When something goes to court, they're on one side, the parents are on the other side, the judge makes a decision. So it's DCS is not a neutral party in this. They're one of the litigants. And so, it doesn't make sense to me, at least, that they would be the ones that have the discretion, not the judge. So to change that now would require a legislative amendment. We'll see. This was in the news this week. If the government has picked up on that, and maybe they'll take a look at that for the spring session of the legislature. Another case, now this one's international, but it caught my eye. Scotland was in the Supreme Court, the UK Supreme Court, and they were trying to, so this was all Brexit related. Scotland had a referendum 10 years ago, anyway, about leaving the United Kingdom, and it was fairly narrowly defeated, not as narrow as the Quebec referendum, which was less than a percentage point, but in Scotland it was, I think, about 55-45 in favor of remaining within the UK. Well, then Brexit happens, and there was a Brexit vote where the UK voted to leave the European Union. Most of Scotland voted overwhelmingly to stay within the European Union. So now there's a little movement afoot to have a new referendum in Scotland for separating from the United Kingdom, and presumably thereafter they would rejoin the European Union. Well, so the Scottish Parliament, Scotland has its own parliament, and they thought, their First Minister, Nicola Sturgeon, said, well, we should be able to, as a Scottish Parliament, it's not quite the same as a provincial legislature, but it's similar. It's a federal system of sorts, more centralized than ours, than the Canadian system, but Scotland wanted to have their own parliament, authorize their own referendum, and that referendum would be a binding referendum. In other words, if they voted to separate from the United Kingdom, that would be enough. That's all they needed to do. Well, they went to the Supreme Court in the UK, and they've now have a ruling that says no, that's not the case. And actually, it was Lord Reid, who's a Scottish judge from Scotland, that said no, it has to go to the Westminster Parliament, the United Kingdom Parliament in London, that oversees the entire UK, to authorize such a referendum. So much less likely that the UK Parliament would allow such a referendum. They seem unlikely to anyway, but so that gives a little more leverage on the UK side. Still lots of discussion to be had there. So the reason I bring this up, I think it's relevant to any, province. I mean, we don't have that situation so much now at the forefront in Canada, but if you look to Spain or other countries, there's sections of countries that sometimes look to secede from from within their own countries, like Quebec from Canada. Well, this ruling from the UK could be influential. What it said is they rejected the quote-unquote right to self-determination under international law, and said that right only applies to colonies or victims of foreign military rule. So not Scotland, not Quebec, not the Basque region of Spain, from what I would say, but others may fit that definition. So UK law is not binding on Canada certainly, but it would be, I think, influential if that issue ever came up here. Okay. So Alberta or Quebec are not going to be able to just decide provincially to leave the country. Many different considerations here with the Clarity Act and many other things, but I think that decision would be influential. Okay, so enough of that. I want to talk about the Emergencies Act Inquiry in Ottawa this week. It was a big week. We had a sort of a lineup of cabinet ministers coming in. We had Marco Mendicino, who was the he was involved in public safety. We had Anita Anand, Department of National Defense, Minister of National Defense, Chrystia Freeland, Minister of Finance, Deputy Prime Minister, and finally the Prime Minister himself. We had some staffers as well. A lot of the testimony this week focused on, all right, what did Cabinet know? Because the question is, did Cabinet have enough justification? Did they have the justification, the legal justification to invoke the Emergencies Act? Some funny things, in a sense, happened with Minister Mendicino. The lawyer for the convoy, this Brendan Miller, got kicked out of the hearing by Justice Rouleau. He was talking over Justice Rouleau, very kind of disrespectful behavior, demeanor, and so he got kicked out, which is something very rare. But then something really bizarre. What he was trying to do, he was trying to make this point or posit this theory that this Nazi flag that was seen in some of the news coverage was actually brought in by a Liberal government staffer. And there hasn't been, as far as I could see, any real hard evidence of this, but that was the claim. And he goes out, the lawyer is seen on video going out into the hallway, tracking down this reporter, Greg McCachran, and saying, hey, you're the guy I'm looking for. Why don't you come in and testify? But it wasn't him at all. It was somebody that works for a lobbying firm out of Toronto who was not in Ottawa, and there was proof. The lobbying firm provided proof that he wasn't in Ottawa during the protests. Or anyway, so some bizarre stuff, not helping the convoy's legal position or their public position, having their lawyer getting kicked out in a bizarre fashion, making this identity mistake, which anyway just looks really bad if your lawyer is undermining their own credibility in that fashion. Minister Freeland talked about the economic concerns the government had, and there was lots of talk about some of the risks that the government was hearing about, some of the advice they were getting from the public service, from CSIS, from others. Now, but much of it focused on the legal interpretation of the Emergencies Act and the standard to be reached, but none of the cabinet ministers would talk about this because, they were receiving advice from the police, from their public service, from the National Security Advisor, from CSIS, all of these things, but they were also getting legal advice. All right, what is the standard to be met to invoke the Emergencies Act? And nobody would talk about that. They would talk about everything else the cabinet learned, but not the legal advice. And there's a reason for that. I mean, any legal advice that an entity receives, a business, a government, an individual, is covered by solicitor-client privilege. And you don't have to reveal that. You can waive solicitor-client privilege and talk about it, but you don't have to. And so the cabinet ministers that came in, including the Justice Minister, David Lametti, wouldn't reveal that. Minister Lametti wouldn't say what advice he had given on the legal interpretation of it. We didn't get that, but I talked about this last week. So the people that watched my video last week, I talked about how the Emergencies Act interacts with the CSIS Act, and the definition of public order emergency and threats to the security of Canada specifically, those are contained in the CSIS Act, Canadian Security Intelligence Service Act. And the Emergencies Act refers to the CSIS Act. So in a sense, at one point, I know the political opposition was saying, okay, well, the head of CSIS said that the protests didn't meet their definition in their act. Well, I didn't think that was the end of the story. I know some people thought, all right, there we go. That's the end of the issue. Justice Rouleau will see that CSIS said we don't need this, or didn't meet the definition in their view. And so that would be it. But it refers to the definition, but the Emergencies Act goes a little further than that. It says it's an emergency that arises from threats to the security of Canada, and that is so serious as to be a national emergency. And then it talks about who makes that determination. It's made by the Governor and Council, that is the cabinet of the country, not by CSIS itself. So that was the interpretation. I assume that was the legal advice that the government had been given, but nobody would say so until Friday, when Prime Minister Trudeau himself took the stand, and he gave basically, he didn't say, hey, this is the advice we received, but he did give a legal interpretation that was consistent with what I said last week and what I'm talking about now, that the Emergencies Act, while the wording is the same as the CSIS Act, it's a broader view of it, because it's not CSIS talking about, wiretapping somebody, spying on somebody, invading somebody's privacy for a national security issue, but this is an emergency of, where cabinet looks at what CSIS is telling us, what are the police telling us, what are, what economic consequences potentially, whether that would count as a factor. We'll see what Justice Rouleau says about that. But all these other security threats that the government would be, having brought to their attention would all be relevant considerations. And so, anyway, the week was all focused on this legal interpretation, and the Prime Minister gave it that, the narrow definition that CSIS uses is not the same as the government would use when deciding on the Emergencies Act. I think Justice Rouleau is going to accept that this wider scope for the Emergencies Act is appropriate. Now, that doesn't end the question, though. I mean, it's still going to be determined, up to Justice Rouleau to determine, well, did it meet that standard? Was it was there, threats to, threat or use of serious violence for political, religious, or ideological objectives? Now, I noticed when Prime Minister Trudeau was talking about that section in particular, that he skipped over the religious part. I mean, he's talking about political or ideological objectives, threat or use of serious violence. Well, we've heard from different witnesses that there didn't really seem to be, there was some violence, but not something that would raise to the level of a national emergency from, I think, most people's interpretation. We've heard some threats that, the government felt there was a threat of further violence or a threat of economic interference, particularly at the Ambassador Bridge between Windsor and Detroit. Well, whether that's sufficient, that's going to be up to Justice Rouleau. I don't think so, but he may find that economic consequences matter. Many times, protests are going to have economic disruptions, or they're going to be the source of economic disruptions, but, they're still legitimate protests. But, so, the other thing is, for Justice Rouleau, though, he can't just say, all right, well, they're, in a perfect world with perfect planning. So we've heard lots about police plans that may or may not have existed. Prime Minister Trudeau was talking about that there didn't really seem to be a good plan in place. The only one that said that there was a good plan in place was RCMP Commissioner Brenda Lucki. But we also heard, so people are going to say, all right, well, there was a plan, and she made this quote that not all options were exhausted. But she was sitting there at the cabinet meeting and didn't mention this, didn't raise that to say, hey, wait, hang on. The RCMP's view is that not all other options are exhausted, and we should, do those first before we invoke this act. She sat there and didn't speak. She wasn't invited to speak, but she didn't, speak up. So what I think Justice Rouleau is going to say, or he's going to have to consider, is, well, what did the cabinet know? They had this legal interpretation that was broader in scope, which I think Justice Rouleau is going to accept. They had inputs from CSIS, from the National Security Advisors. They saw that the police were disorganized and didn't seem to be able to handle things on their own. So, all of those factors would seem to point to cabinet making, a not terribly unreasonable decision to invoke the Emergencies Act under those circumstances. I mean, it has to have, that when you're thinking about how something is reasonable or not, there's two elements. There's a subjective and objective element. Subjective being, did the person honestly believe that to be the case, that they needed that? And, all the cabinet ministers seem to, at length, talk about how they felt that was the case, everything they were hearing told them that was the case. Now, objectively, we've heard some evidence that, the Coutts, Alberta situation was under control basically the day before. It was starting to dissipate. The Ambassador Bridge situation, that seemed to be under control, or, that was being resolved. That there wasn't really a lot of, there wasn't any substantial, large-scale violence anywhere. And the other thing was that it was revoked at, fairly early on. The RCMP wished it had gone on longer, but the real reason it was revoked, though, we should recall, was that it was going to go to a vote in the Senate, and the Senate was likely to reject the invocation of the Emergencies Act. So, anyways, remember all of those things. Those are all the things that Justice Rouleau is going to have to consider, but when he's considering that, he has a wider scope than I think many on the convoy side and the opposition side may have hoped he would, use when they first read the act and saw that it was tied to the CSIS Act. Okay, gone on long enough about that. I hope everybody found that enlightening to some extent. The Emergencies Act Inquiry has wrapped up its hearings. I think there's going to be some maybe some expert opinion or some other opinion, but I think the proceedings themselves are finished. We'll wait to hear what Justice Rouleau's decision is going to be. And then we're going to, by the way, in the time since, this is just a timing issue, coming back to the Mass Casualty Commission. The Mass Casualty Commission report is coming out the end of March of next year. The emergencies, since that inquiry proceedings finished, the Emergencies Act Inquiry has started and will finish and give a final report in the time since the Mass Casualty Commission finished their proceedings and before their report is out. So just a comparison of the two inquiries. I think many people in Nova Scotia that have suffered through the Mass Casualty Commission proceedings are looking at the Emergencies Act proceedings with some envy and I think in terms of, of course the Emergencies Act Inquiry is going quickly and maybe too quickly for some, but much more quickly and more efficiently than the Emergencies Act, than the Mass Casualty Commission. Okay, that's it for the 11th of November, the 27th of November 2020. Thanks to everybody for watching. Thanks for tuning into all this, and we'll see you next time.